Madam Chair and honorable members, Clause 3 be amended as follows. Roman 1, 47, web of interest and Roman 1, tax outstanding at 30th June 2024 will be the total principal less the tax already paid. 2, the interest and the penalties up to 30th June 2024 are waived. 3, the interest which has accumulated from 1st July 2024
Let's agree on the text.
Yeah, we shall do the text. Yeah, because this is what we discussed.
AG help in drafting.
Yeah, okay, let me just make this so then we can conclude the drafting. The principal tax outstanding at 30th June 2024 will be the total principal less the tax already paid. 2, the interest and the penalties up to 30th June 2024 are waived.
That is the same as 1.
No, that is the principle. No, now the one which we are going for apportionment. 3, the interest which has accumulated from 1st July 2024, because that was not covered by the waiver. 1st July 2024 to 30th June 2025 will be waived on Pareto basis as the taxpayer, Pareto, as the taxpayer pays the taxes by 2026. Of course, the justification for that is that they divide it, whatever. 4, the interest from 1st July 2025 will be charged on all the outstanding tax until paid, because this one is not the one covered by the bill for waiver. And I find that I think this was a recommendation that URA should reconcile the ledgers, but we never gave it a time frame.
That can be in the law.
Yeah, so we can say URA should reconcile the tax ledgers. We can say within 30 days.
No, the minister will instruct URA. Draft, redraft.
Thank you very much, Right Honorable Speaker. Right Honorable Chair, I think Honorable Nandala has really put together the principles as were agreed, and we are on the same page. Now for the drafting, we wanted to propose that we leave Clause 3.1 as it is, Clause 3.2 as it is, and add Clause 3.3 to read as follows. For avoidance of doubt, subsection 1 and 2 shall apply to the interest that accrues on the principal tax from 1st July 2024 to the date the taxpayer pays the principal. Meaning that if the taxpayer starts paying the principal amount in, say, August of 2025, that taxpayer has until August 2026 to pay off the debt. If by July 2026, if he has paid off the debt, but there was interest that had accrued, it will also be waived in accordance with 1 and 2 above. Beg to submit.
Thank you very much. I think since you have brought avoidance of doubt, now let me also add, for avoidance of doubt, the principal tax outstanding as at 30th June 2024 is the total principal less the tax amount paid. Because we want to be real on the same page.
Yes, Katesh.
I think that I get where you are going, but when we talk of outstanding principal tax, it's expected that you would have less stuff. So my view is that the framing, the way the Attorney General has framed it, deals with the period we were discussing in our caucusing, but also by leaving the clauses they are, the way they are, caters for the backward period. So I would like us to say that we should go with the amendment that he has captured, that he has proposed, because it caters for the issues that we are worried about.
Nathan, it captures what you wanted to be captured.
Fine, no, but since we have all agreed on the answer.
Minister.
The other point, Madam Chair, the other point, which now, since we have covered, is the ledgers. We had said we can put it in the law. Do we propose a period for...
No, that one doesn't come in the law. Yes, Honorable Chair, are you in agreement with the Attorney General's?
Yes, I'm in agreement.
Minister?
I was part of the meeting.
Do you agree?
So collective responsibility.
Honorable Musasi, do you agree?
I do.
I put a question that clause 3 be amended as proposed by by Honorable Nandala and amended by Honorable Attorney General. Those in favor say and the contrary nay. The ayes have it.
Clause 3 as amended.
I put a question that clause 3 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 4.
I put a question that clause 4 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 5.
Clause 5. Clause 5. Let him first read his amendment, then you come in.
Right, Honorable Speaker, I will read the amendment proposed by the committee. Clause 5 is amended by inserting immediately after proposed section 93A, subsection 2, the following. An operator of a casino, gaming, or betting activity who is required to receive a wager or money staked and only make payouts through the gaming and betting centralized payment system, gateway system, referred to in under subsection 1 shall comply with subsection 1, wherein a period of 12 months from the date of commencement of this act. Justification: to give a transition period of 12 months to an operator of a casino, gaming, and betting activity who is not compliant with the proposed subsection 93A at the commencement of this act, to integrate the equipment to centralized payment system.
Medi?
Right Honorable Speaker, Madam Chair, I have a huge problem with creation of monopolies, mainly through payment systems. The new wave of multinationals coming to ignorant African countries and robbing them clean is through monopolization of their taxation mandatory payment systems. A case in point, Madam Chair, is how the URA came to us through the Ministry of Finance and stated that someone had presented blockchain technology and smart technology that will be used by a company that had not even been 5 years old, registered in Delaware, called Riponami, to help collect rental income tax. Ugandans were whipped. We came here and even made alterations to the rates of payment of rental income tax that increased. Without the company deploying any tool of technology, today it works out with a huge percentage of money out of the taxpayers' contribution. Such bogus agreements, Right Honorable Speaker, have put this country at a loss of not only revenue, but also have killed innovation. The same is being introduced in this wave. Recently, the government, through an agreement signed with UAE investors, an agreement in the name of creation of a single payment gateway system for all payments made for government contribution and taxation. At the end of the day, these companies exactly know that if you collect billions of dollars and they take a percentage, even if it's $120 million, they'll have robbed you clean. These things we can do. Dear colleagues and comrades, your children can do this work exactly. Let the central bank and Ministry of Finance come and tell us just 2 systems that they have not tendered out, that they are running directly. I challenge the minister is here. Tell me just 2 systems that you're running and you've not tendered out in form of payment systems. So what we are saying, Honorable Attorney General and Right Honorable Speaker, is that all those that have been paying are going through various payment platforms, some that are even owned by your children, meaning there is no monopoly. What the URA has to just do is to create an interface with them, and you'll see all the taxes. So why create one monopoly that you don't even talk about and legislate in anticipation that the Ministry of Finance intends that we give them an enabling law to create a tool where they create one centralized system. The centralized system, Right Honorable Speaker, is already there. Under the Act, anyone that is paying electronically must be approved by BOU. Therefore, what they intend to do is creation of another company. For avoidance of doubt, this will come to pass, that we are legislating in anticipation, and we'll be back to round 1, and you'll exactly know that this was tendered out. And before you know, this is money being shared by government officials and multinationals.